Good morning, everyone. Happy Monday. I hope everyone had a great weekend out in the sun. Hope everyone is staying safe. This is Sandy Baruah from the Detroit Regional Chamber, and welcome to the latest edition of our Tele-Town Hall series. Today, we're going to answer one of the most pressing questions from businesses all across the state, and that is, what do I need to do to ensure that my business is ready to safely start up once I'm given the green light to do so? And to answer those questions today, we're very pleased to have two partners from Foley and Lardner, John Birmingham Jr. and Jeff Knopf. John and Jeff, welcome to the show. Thanks so much for being with us this morning. Apologize for that. Right, we're going to start with a 60,000-foot question, and John, I'm going to direct.
Thanks, Andy. Appreciate the comment.
Great. No, thank you all for being here. This is going to be highly valuable. We've got a lot of people on the line for this. So, John, 60,000-foot level, what should employers be thinking about before they open the doors to both their employees and their customers?
Thanks, Andy. I think I should first start out with these are very challenging, unique times. So we really need to, as labor and employment lawyers, HR professionals, business leaders, kind of throw out our playbook, right? Because these are really unique, different times. When we've got new laws, new and modified laws, we've got, federal guidance, we've got state executive orders, we've got even county orders that we have to deal with. Then we've got existing laws that are modified. We have the EEOC chiming in and changing their guidance on how to kind of treat people from an ADA perspective. And we're really advising, it's really interesting for us, Sandy, maybe not for everybody else, but we're giving advice that we would have never given a couple of months ago because the laws are so relaxed. Then we've got, the scientific facts changing all the time. And so we've got to keep up with that. We've got all these different stakeholders, right? We've got the government, we've got our business leaders, we've got customers, vendors, contractors, employees, unions. So there's really a lot to keep in mind here. And so what that means is the employers really need to have a carefully thought out plan before as they return back to work. In fact, if you look at Governor Whitmer's executive order, requires a preparedness and response plan before the doors are open to go back to work. So what do we kind of advise there? First of all, I think you got to identify the objectives. And the obvious objectives, I think, are health and safety, good business operations, cost. We have to factor in costs and expenses, and employee morale. Then I think we've got to really identify the leaders. It's important to have a different person responsible for different areas. You want one person responsible for developing the protocol and the guidelines, another person responsible for getting the equipment, for communicating with employees. Very important to do that. It's also really important to have a communication plan. You need to be able to communicate clearly to customers and to employees, and you need to assure them that what you're doing is appropriate and will keep them safe. You got to figure out what supplies you need, what equipment you need. Okay, you have to figure out how are we going to train people as we move back to the workforce, and are we going to have to change our operation in order to keep people safe? So there's really a lot to think about here, and employers really need to kind of go outside of their typical playbook and think about, okay, what do we need to do differently in order to kind of comply with the law and also to deal with all these different stakeholders.
John, just a quick follow-up on that. You said you said several intriguing things, but one of the things you said was that you're giving advice to clients now that you never would have contemplated giving advice. Can you just give us a quick example of a piece of advice you're giving now that under normal circumstances you never would have thought of giving?
Absolutely. It's kind of an evolving thing. Boy, it was like 3 weeks ago, it was like, maybe we should take people's temperature. And now we should take people's temperature. The EEOC, if you would have gone back 2 months ago, the EEOC would have said, you cannot ask people about their medical condition. You cannot take their temperature. You can't do all the sorts of things that are really going to become regular routine actions moving back forward as we emerge into the workplace. So that's an example of it. The EEOC's regulations said because it's a pandemic, you can ask all these questions. Before you couldn't.
I'm glad I asked because that's a question that we're having internally with our reopening plans. So John, I appreciate that. Jeff, let's turn to you. What does a good reopening plan look like?
Yeah, so great question, Sandy. And really, you have to think of this very independently. Each employer is going to be different, right? Everybody's got different size operations. You might be a manufacturer, you might be in an office setting. So there is no one size fits all. That's for sure. All of our clients have different challenges because they have different sizes of their workforce. They have people that can work from home. They have some people that can't work from home, and so that's going to be dependent on your facts and circumstances, on your business operations. And so it's much different for a law firm or an accounting firm than it is for a manufacturer that is required to have people working very closely with each other. I have one client that is in the construction industry, and they pour concrete, and so it's a situation where you have to have employees that are working very closely with each other in order to operate the equipment. They have to pour cement, and they have to carry equipment together, a two-man lift, and so that requires different considerations for what you need to do in order to keep the people safe, as John mentioned. And so I think when you put together your plan, your preparedness plan, the things that you really should have in mind are the things, and by the way, I'll throw in a plug for Foley. We have put together a handbook for opening, for businesses that open, and it has the kind of things that you'd want to consider when you're thinking about opening or reopening your business. And so the things that come to mind are things like social distancing, things like wearing protective equipment, masks, temperature checking, as John mentioned, shift staggering if possible. These are things that are outlined in Governor Whitmer's order. She links to a document that's put out by OSHA, the Occupational Safety Health Administration, that talks about reopening, and it covers those main topics. So those are the things I think that people should really be considering right now. But there is no one size fits all, and I think you have to consider what works best for your business with respect to those various topics that I just mentioned. John may have other thoughts as well.
Jeff, just a follow up there. Oh, I think hang on. Sorry, Jeff, do I have you back?
I'm here, yeah,
Yes.
But we lost your video.
Okay, sorry about that. Yeah, I'm turned off my video because I think I might be having an internet connection issue. So Jeff, a quick follow up on the Foley and Lardner handbook that you mentioned. Is that broken out by different type of office environment? So for example, you said that it's going to be very different for manufacturing than it is for an accounting firm.
Yeah, so we tried to hit some general topics for all kinds of employers. It is geared a little towards the manufacturing sector, which, being in the Midwest, that's what a lot of our clients are. But I think generally it covers all the main topics that you'd want to hit upon, the things that I mentioned: temperature checking, cleaning the workplace, and PPE and things like that.
Okay, great, thanks. That sounds like a really useful tool. John, turning back to you, this is probably one of the biggest questions that I get when I'm talking to business leaders one-on-one, and that is legal liability. What are the risks, the legal risks that employers need to consider when bringing back employees into the workplace, and maybe if you could expand on, what happens if an employee gets sick, at the workplace or because of the workplace? Big questions.
Yeah, and a lot of people are very worried about that, Sandy. I mean, it literally didn't take more than 1 or 2 weeks after the COVID-19 crisis hit when lawsuits were already popping up. Walmart, for example, got sued because one of its employees contracted COVID-19, and the allegation was that they didn't do enough to keep the employee safe. So the legal risks are definitely out there. Let's kind of go through them a little bit. So let's say that we do everything we can, but someone contracts COVID-19 in the workplace. Typically, workers' compensation would provide the exclusive remedy for that. Now, first of all, though, somebody to get workers' compensation would have to show that they actually contracted COVID-19 in the workplace. Some other states have actually said there's a presumption. They changed their workers' compensation laws, and they said there's a presumption that the person did contract COVID-19 in the workplace. Michigan, except for first responders, people who are doctors, nurses, police officers, except for first responders, people in Michigan still need to show that they contracted COVID-19 in the workplace in order to get workers' compensation. However, the workers' compensation remedy is something that is really important with respect to liability, because if you didn't have the workers' compensation exclusive remedy, a plaintiff's attorney could file a wrongful death case if somebody contracted COVID-19, and they could simply say you were negligent in not protecting this person. With the workers' compensation exclusive remedy, they have to provide that either you intentionally wanted the person to get hurt or you acted with reckless disregard. So I still think it's super important to do everything we can to protect the health and safety of the employees, so that we can say, listen, there was no reckless disregard, and workers' compensation is the exclusive remedy if someone files a lawsuit. Because Sandy, the people that you talk to, what they're most worried about, I think, is some huge multi-million, well, I don't know if they're most worried about from a legal perspective. They might be a huge multi-million-dollar lawsuit saying, you got my family member sick, you got me workers' compensation exclusive remedy, though, right? It would not apply to a contractor who gets who contracts COVID-19. So that person could say that we were negligent in protecting them in the workplace, and it wouldn't apply to somebody's family member. So if somebody's family member contracted COVID-19 from a worker, and we were negligent with respect to how we kept the premises safe and the training and all the other PPE that Jeff mentioned, then that family member could potentially sue in a wrongful death case. So this is really something that that you need to really look out for. There's a number of other. I'm sorry.
Please, no, please go ahead. I was going to interrupt.
Okay. No, there's a few other legal issues I'll just kind of tick off that are really important. There's Fair Labor Standards Act issues, right? For example, if somebody is standing in line to get their temperature checked, do we need to pay them during standing in line? And that's a debated legal issue for many labor and employment attorneys. I personally think that it's probably a better idea to pay them while they're standing in line to get their temperature checked. Other people would say that it's not legally required. That's kind of going to be a cutting edge issue that might get litigated. I'd also tell people, make sure you keep your eye on the WARN Act. As you bring people back to work, a lot of my clients have said the WARN Act does not apply unless a layoff lasts more than 6 months. And I think when we first started COVID-19, Sandy, I think a lot of my clients said, there's no way that this layoff is going to last more than 6 months. Now, I think it's becoming a little less clear whether that's the case. So under the WARN Act, if more than 50 people and 1/3 of the workforce get laid off for more than 6 months, you've got to give a WARN Act notice. So I tell people, keep your eye on the ball on that. It's really important to kind of be continually reevaluating whether or not the WARN Act would apply. We've got other defenses there. There's an unforeseeable business circumstances exception. There's a natural disaster exception, but I wouldn't rely too strongly on that. Just a couple other issues I'll tick off from a legal issue standpoint. ADA issues, got to be really careful. I mean, as we said, they've relaxed the standard, but you need to be careful with respect to record keeping and with respect to confidentiality. And you might also need to accommodate someone. I think Jeff is going to talk about that also. You need to comply with OSHA. And if an employee raises their hand and says, I think this workplace is unsafe, you have to make sure that you don't retaliate against the person for raising their hand. There's also union issues. The unions will want to negotiate terms of coming back to the workplace. There's an argument that your management rights clause in your collective bargaining agreement gives you the right to do certain things. But from a practical perspective, we all know that there's going to be discussions with the union, and it's good to come to an agreement with respect to that. There's a myriad of other legal issues, but those are some of the biggest ones, Sandy.
Well, no wonder business leaders are skittish or more than skittish. That sounds awfully complicated. Now, here's just a quick follow-up. When if an employee does fall ill, how does the employee claim that it was due to the workplace? Obviously, the employee is going home, possibly taking public transit, shopping at the local grocery store. How is that going to unfold?
That's a really good question. And that's exactly why some states, like Illinois, for example, Sandy, has basically said the presumption is that the person was infected at the workplace, just to combat that causation issue that you just mentioned there. But I think what would happen is somebody would say, well, a person working in the workstation next to me tested positive for COVID-19. You know that, Mr. Employer. I tried not to go to a lot of other places, and therefore the causation is there. But that causation issue is going to be, a big issue and a difficult issue for a person to prove. But it'll be, those cases will be litigated in the workers' compensation format, and they'll be litigated in the wrongful death format too.
Yeah, I think one other thing, John, just to add to that, but I think in situations where you have multiple people that are testing positive in the same workplace, it's a little easier to prove. You had, a number of people in the same environment.
Well, I assume if you're an employer and you have multiple people testing positive, there's probably more extreme measures that you can and should be taking under a circumstance like that.
True. Yes, I think you should, obviously, to combat the legal liability, the employer should be taking as much.
Absolutely, that's absolutely the case, and really, it kind of goes back to, with respect to all legal issues, Sandy. It kind of goes back to you need to do everything you can to keep people safe, and you have to have a protocol. If somebody tests positive, we have a whole, and Jeff mentioned the Foley and Lardner resource book. We've got a protocol in there which describes exactly what should happen if somebody tests positive for COVID-19, or if a family member tests positive for COVID-19. And it involves quarantining the person for 14 days. It involves not having them come back to work until they get a release. It involves telling the people, at least in their immediate vicinity, who they had frequent contact with, that the person that somebody tested positive for COVID-19. And that's an interesting question right there, right? Whether somebody's right to privacy, not to have it disclosed that they tested positive for COVID-19, whether that outweighs the right of a person who's working close to them to know who it was. What we've kind of advised, Sandy, is get the person's consent. Try to get the person's consent with respect to the ability to disclose that they tested positive for COVID-19. If you don't get the person's consent, then it's usually better to just simply say somebody working close to you tested positive to COVID-19.
Sure, fair enough. A question for either one of you, but let's start with John. What about if an employee refuses to return to work after the employer starts up and running again?
That's a really good question, and it's a very difficult question. And this is something, Sandy, where all these laws that are really designed to help people, and they should help people, are sometimes come in conflict with somebody's motivation. What I mean by that is, for a number of my clients, the unemployment compensation that somebody is able to obtain under the CARE Act might be as much as $965 in Michigan, right? So $965 equates to more than $50,000 a year. So you might have a situation where you want to start back up, and somebody says, just from a purely economic standpoint, says, you know what, I'm making more money on unemployment compensation than I am working for you, and so I don't want to come back to work. And in most situations, a pure fear that they might come and contract the COVID-19 virus is not going to be enough for them to refuse to come back to work. And if they refuse to come back to work because of that fear, they should typically and technically not be able to continue to get unemployment compensation. So one of the things I've advised my clients, and this really sounds harsh, I know, is that when you call people back, and somebody objects to coming back, we will consider this a voluntary quit if you don't come back to work, and we expect that your unemployment compensation benefits will end at that point. Now, I say that, but I think we've got to have a couple of caveats with respect to that, because we've got to treat people with sensitivity and empathy. So if somebody says that they have a vulnerable condition, let's say they have emphysema or diabetes, and they say, listen, I have this vulnerable condition and I can't come back to work, that might be a situation where you need to bend the rules and accommodate. I think Jeff's going to talk about accommodating that person under the ADA. But typically, if they refuse to come back to work and it's just a generalized fear or anxiety, I think you need to work with the person, but you need to tell them that if they don't come back to work, their unemployment benefits can be.
Jeff, can you expand on that?
Yeah, for sure. And so John's right. I think that.
So I think there's three categories, just quickly, three categories. There's a generalized fear, and I think that you tell people you need to come back to work. Employee, you need to work with them. And then there's the employee who actually qualifies for, Family First Act or FMLA, and you need to let them stay out of work. Jeff, did you want to add to that?
Yeah, so John's absolutely right about the way that the Americans with Disabilities Act requires small businesses and businesses to comply with accommodating employees who might need a reasonable accommodation if they have a disability. And so if somebody does have a pre-existing condition, and a couple of clients that we've had have already had this issue come up where people are just fearful to come back to work, and they have an older workforce who might be more susceptible to getting coronavirus. And so for those people, I think to the extent that they have a doctor who can vouch for them and fill out the paperwork that shows that they have that pre-existing condition, I think then the employer does have an obligation to work with that employee to try to provide them a reasonable accommodation. That could include time off. It could include maybe teleworking. A lot of clients say, well, we don't have a teleworking policy, and we don't let people work from home. Now, obviously, in a post-COVID world, that's different, right? So I think employers have to look at their policies and perhaps make adjustments on the fly and say, maybe we didn't allow teleworking before, but now we're going to have to consider that for definitely for some people who are at higher risk. I just want to mention, the Families First Coronavirus Response Act came about to help small businesses, as you know, with providing tax credits for employees who might need leave. Another issue that's coming up, and I think it's going to continue to come up through the summertime for sure, is that employees can't come back to work because they have small children who because of their schools being closed or camps being closed in the summer, are going to need time off. And for those of you who are covered by that act, the law says that you have to allow somebody to take initially 2 weeks for emergency paid sick leave, up to 80 hours at 2/3 pay, up to $200 a day for them, in order to take care of a child or someone when there's no other suitable adult who can care for that child, and the person needs time off from work and they can't telework. And so then they would get the initially 2 weeks off for the paid sick leave, and then up to 10 weeks additional for expanded FMLA for the same reason, for school closure. So so keep in mind that may be a reason why people can't come back to work, and it's because they have difficulties with childcare. But that may be for some people up to a 12-week time period under the Families First Act. Now, there are some qualifications. If someone has already exhausted their FMLA, then they wouldn't be entitled to an additional 12 weeks. Keep that in mind. And generally, the employer is going to get a tax credit for those amounts that are paid pursuant to the act. Now, if you're a bigger employer and you don't qualify for those tax credits, then there's no obligation necessarily to allow somebody time off for childcare. But again, keep in mind that you want to keep morale up in the workplace, and I think it's unfortunately, given the numbers you're dealing with, it's not a reality that most employers can just simply say we're going to terminate our workforce, and because then there will be nobody to do the work and nobody trained to do the work. So I think the reality is that the employers are going to have to work with people when it comes to childcare, even if they're not covered by the Families First Act.
I'm going to turn over the rest of the questioning, and to close out the program, my colleague Brad Williams, the Vice President of Government Affairs for the Chamber. Brad.
Well, thanks everyone, and we've got more questions than we're possibly going to be able to go through. So if the more we can get through as quickly as possible, that'd be awesome. We've got one question in here, Jeff, about people who are ill, maybe not with COVID-19, and my guess would be that the right response is, even if you just have a cold, to stay home. But I'm thinking particularly about, we're coming upon seasonal allergy season. I know both my wife and daughter have seasonal allergies. What do we do in those instances? Because those symptoms can look pretty similar to illness. How should employers react in those situations?
Sure. Yeah, Brett. It's tough because we're not doctors, and we have to almost assume that if someone has a fever that is 100.4, in some cases, that's what the standard by the CDC put out. But some jurisdictions, like Massachusetts, for instance, they use 100 degrees. So if somebody has a low-grade temperature, 100 degrees or more, then you can pretty much say that that's a potential symptom of COVID. Now, they've recently expanded the symptoms to nausea, potential stomach cramping, other types of things that might not necessarily be shortness of breath or or fever, but I do think you have to err on the side of safety. So if somebody is presenting with a cold and it's lasted for, they say they were around somebody who also was having similar symptoms, I think it would be best for that person to stay home.
What about landlords who have common bathrooms in their building, or even employers that have common bathrooms in their building? What precautions should they be taking to ensure that they're keeping their employees safe?
John, do you want to grab that one, or do you want me to?
Yeah, sure. I'll grab that one. So I think if a landlord has a bathroom and they're dealing with contractors, then I think that they're going to potentially be responsible for an illness that befalls the contractor. So I think they need to work with. So to the extent that there's a contractor who they're working with in the building, they need to work with that contractor and make sure that they have a team-based approach to keep the bathroom clean, and to really, as Jeff said, use the extra cleaning services. You can't go back to business as normal. You're going to have to do the extra cleaning that you have. But I think to the extent that there's a contractor or there are people who are not your employees who are using your restrooms, if you're negligent with respect to those people, the workers' compensation exclusive remedy is not going to apply, and you're going to be in a situation where you're potentially looking at a wrongful death suit. So you really need to partner with the building owner, partner with who you're leasing the building with, make sure that they're doing the right things, and work together to really do more than as usual and keep the bathrooms clean and extra sterile.
So there's a number of questions in here about testing, and I know we're not at the capacity for testing that we want to be as a society, but once we are, what are the testing obligations and rights for an employer to keep the workplace safe? Can an employer require a testing regimen for employees, and how do you recommend employers approach that?
So right now, I think we're at the point where temperature testing is being requested or required in some cases for many employers. And I think that having a temperature, as long as the temperature testing is done correctly, where the person who's actually performing the test is correctly wearing PPE, they have a mask, face shield, and they have a thermometer where they can take the temperature from a distance from the person who's being the test is being administered to. I think that's appropriate because it's a good way to screen out somebody who's actually has symptoms of COVID, potentially a fever at least. But then in terms of conducting swabs and doing tests or blood tests or anything like that, I don't think employers are at that level yet. And unless you're in like a medical capacity and have that capability, I don't see that happening for a while.
When, fingers crossed, we get to a point where we have vaccines available, would that be something that employers can require as a condition of employment?
Well, that's a really interesting question, and that's something that, again, that's a good example of how standards are evolving, and we have to evolve with respect to science. I could potentially see that being allowable, and again, Brad, I think that goes back to 2 months ago. That would have been a flat out no way. Can you do that, right? I think a couple of months from now, if vaccines are available and there's a direct threat to the employees in the workplace, potentially, yes. And potentially, especially in a really safety sensitive sort of situation, potentially, yes, that you could potentially require them to do that. That's an example, though. That's a pretty far bridge towards somebody's privacy.
There's so many questions in here. I think we could probably spend a couple hours trying to get to them. Oh, so sorry.
I think that would be an issue where you could definitely see it litigated. But given where we are and given the evolving accountability,
I think we've got a little bit of lag in John's response time. So it sounds like we keep trying to cut him off, but that is not our intent. We've got so many questions in here that I apologize that we're not going to be able to get to them all. But I do have, I think, one more question that seems a little bit off the wall, but is, I think, illustrative about some of the complex questions that employers are going to have to deal with as we're going back to work. And the question is, how do you deal with a scenario like we were talking about before, where an employee maybe is a little bit better off on unemployment than they would be coming back to work, and they try and manipulate the system, saying they aren't feeling well on a day-to-day basis. You've got the temperature or the pre come to work screen where you ask if you have symptoms, and I could say I have a cough every day to avoid coming back to work. I think these are the types of things employers are worried about. Hopefully it doesn't come to that, but are you thinking these types of situations through where an employee is kind of gaming the system here in the future as we open up? And what advice do you have for employers going forward? And after that, I will hand it back to Sandy because I know we're right up against our time.
Yeah, if you want to handle that one.
Yeah, sure. So I think that's true. You are going to see employees that do try to take advantage of the system to the extent that they try to collect unemployment beyond the time that they would otherwise be required to come back to work. But I think employers generally have to send a message to employees that, look, this enhanced CARES Act money is short-lived, right? It's only through the end of July 31st, 2020, it cuts off. And they have to be thinking, employees have to be hearing the message that, look, as a business, we need to be focused on the long haul. We need to be considering, 6 months out, a year out, and what is our workforce? We want to have the best company. We want to serve our customers well and do the things that are required in order to build a team message, a team approach to having employees feel that they can come back to work safely. And I think a lot of employees do want to come back to work already. They're tired of this being cooped up in their houses. They want to come back and they want to contribute to the society again. And, to the extent they can do that, I think as long as they feel safe, perhaps that might be a way to detract from some of the gamesmanship that might otherwise take place.
Great, well, thanks. And Sandy, I will hand it back to you.
Great. Listen, gentlemen, thank you so much. This was excellent programming. We have so many thank yous, and this was really great in the chat box. So really appreciate our friends from Foley and Lardner being with us today. I will share the Foley and Lardner website with you all because I assume that's where your handbook is, gentlemen. Is that correct?
Yeah, probably best to email me directly. I'll give you my email. It's jkopp@foley.com, jkopp@foley.com. Sandy, we also have some forms that are good that employers might need for employees that are requesting time off for the Families First Act. Things like because their kids' school are closed, they might want time off. We have the enhanced or newer versions of forms for FMLA and things like that as well that I can provide.
Excellent. That's great. Well, gentlemen, thank you again. This was terrific information. Want to thank everyone who was on the line. We had a lot of people, several hundred people on the line. So we thank you for your time. So for everyone, have a great week. Stay home, stay safe, and hopefully we'll get some sunshine back. Thanks so much. Have a great day. Best from the Detroit Regional Chamber. Take care.
Thanks, Andy. Thanks, everybody.
Thanks.
Take care. Bye-bye now.